We will go on the record in the matter 26 CF 74, State of Wisconsin versus Adrian Belisle. The state appears through District Attorney Kevin Schmidt in person. Mr. Belisle appears in person in custody with counsel Joel Feliski. We're set today for a preliminary hearing. The court has been informed this is a waiver of a preliminary hearing. Is that correct, Mr. Feliski?
That is correct, Your Honor. I did discuss the preliminary hearing with Mr. Belisle along with an offer made contingent on waiver of the preliminary hearing with him. Based on that offer, at this time, he would like to waive his right to a preliminary hearing. I have completed and reviewed a waiver form with him, Your Honor, and that has been filed in the case file here as document number 14.
All right. Thank you, Mr. Feliski. Mr. Belisle, I have in front of me the electronic document number 14, which is a waiver of right to preliminary hearing. Did your attorney go over that document with you thoroughly?
Yes.
And do you understand it completely?
Yes.
And he explained everything to you word for word?
Yes.
And if you didn't understand something, you ask him to explain it to you until you did?
Yes.
So you're telling the court you fully understand what it means to waive a preliminary hearing?
Yes, Your Honor.
Do you understand, or is that your signature on the bottom of the document? Did you sign it?
Yeah.
And do you understand that once you give up the right, it's forever and you can't get it back?
Yes.
Has anyone made any threats or any promises outside of an offer from the state for you to waive your right to a preliminary hearing?
Yes.
Did they threatened you?
No.
Did they promise you anything?
No.
The only thing that was somewhat of a promise was the offer presented, correct?
Yes.
And so are you are you waiving your right to a preliminary hearing freely and intelligently? That means you're telling me you fully understand what you're doing here today?
Yeah.
And voluntarily?
Yeah.
I'm going to find that based upon this information and as it relates to the preliminary hearing matter only, and the fact that Mr. Feliski thoroughly went over with Mr. Belisle what a preliminary hearing is and ensured that he understood what a preliminary hearing is and what it means to waive a preliminary hearing, I will find based upon those points that Mr. Belisle is competent to waive his right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set it for another date.
Your Honor, I'm comfortable proceeding with the arraignment here today. As the information mirrors the complaint, I trust that Mr. Belisle understands the charges here and the maximum penalties. We will waive any formal reading and to all counts enter in pleas of not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one.
Yes.
Okay, now let's get another date for you.
Your Honor, if I may, this matter has reached a resolution. Mr. Belisle has agreed to a deferred judgment of conviction as part of this case. So if we could set the next date and time, the next available date, I should say, for a plea and sentencing.
The Teskey case at this point is a go. August 6th and 7th, I believe has reached a resolution. I have not yet taken a plea and it's just been stated it most likely will resolve. If you feel comfortable setting August 6th, knowing that it may not be able to occur if the matter doesn't resolve, we can set it for August 6th because otherwise we're looking at mid to late September.
I see, Your Honor. I suppose in that case, then August 6th will work.
How about 10 o'clock on August 6th?
That will work.
And I will let you know that I will know if it is going or not going for sure. July 22nd at 2:30 is the hearing, okay?
Would it be possible for it to be 10:30 instead of 10?
Did you double book a jury trial?
No, but if the jury trial doesn't go, I'd like to speak to public safety that day. They want to speak to me about a proposed ordinance I made.
I want to as well.
Hmm.
So I will put that on my calendar as well if that doesn't go. So why don't we just say 11?
That will work.
All right, 11 o'clock on August 6th. Anything further?
No, Your Honor, thank you.
We're adjourned. Mr. Schmidt, what time does public safety start, at 9 or 9:30?
9:30.
That's what I thought. Thank you. I'm going to make sure that I have that on my calendar.
And this one might go a bit longer because for the
We'll go on the record. I can wait. We'll go on the record in the matter 26 CM 52, State of Wisconsin versus Jacob Pardun. The state appears through District Attorney Kevin Schmidt in person. Mr. Pardun appears in person without counsel. We are in victims' rights compliance.
Yes, Your Honor.
All right. So, Mr. Pardun, you failed to make your last court hearing. The court issued a warrant with certain dollar amount bail. However, then the next day or something of that nature, you did write a letter to the court indicating that you just simply thought it was a different date and you didn't know you missed court. Is that correct?
Yes,
And I did allow the clerks to quash the warrant for a hearing today. You're not retaining Mr. Zuber?
no, I'm not.
You're going to represent yourself?
Yes,
Okay. Now, Mr. Schmidt, can you please recite the offer again for Mr. Pardun since he is representing himself?
ordinance DC for costs.
Okay.
Which I think is $114.50.
But isn't there restitution?
No,
That the
victim
rest-
said that he fixed the door.
Okay, so the dispositional supplement is not correct. Okay. So an ordinance for cost?
Yes.
All righty. Okay, so do you wish to accept that offer?
yes,
All right, so as to count 2, disorderly conduct, formal motion to amend,
So made.
granted. How do you wish to plead?
not guilty,
Not
Or-
guilty.
or-
It's either guilty or no contest.
no contest.
Okay, the court will accept your plea of no contest. I will assess $330.50. When can you have that paid?
Today,
Excellent, thank you, because then you get me off your back. You don't have to worry about it. So go and get that paid when we're done here today. The other matter is dismissed and read in. We are good to go. Thank you, Mr. Pardun.
thank you,
Hey, the lady, on your way.
will do.
Thank you. That was somewhat of the auction play. You've probably never watched the show. Thank you, Ms. Malsum. We are back.
Okay, back.
Thank you. We will go on the record in the matter 26 CF 68, State of Wisconsin versus Travis Wessles. The state appears through through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel, in person with Mr. Wessels. We're set here today for a preliminary hearing. Mr. Feliski, is this matter proceeding as such?
That is correct, Your Honor.
Excellent. Thank you. Mr. Schmidt, please call your first witness.
I called Jeff Carroll.
Deputy Carroll, please come forward, raise your right hand, you'll be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Deputy Carroll was hired to be the court security office on July 1st is when he started. He is a witness in this matter and this case. I will tell you, and I'm sure Deputy Carroll will confirm, that I've called him out on things, and just because he is an officer and now he's in the court security officer, I don't find his testimony to be more believable than any other testimony than if you were to testify, Mr. Wessels. It is based on a credibility. I just wanted you to be aware of that. He's new to here, so I don't even know much about him. But Mr. Feliski, you're aware that he is the court security officer. I just wanted to make that on the record so that you can talk to your client and just let me know.
Of course, Your Honor. Thank you.
Is it all good?
Yeah, I mean,
Yep, we don't have an objection, Your Honor.
All right, so you may proceed.
Can you state your name, spelling your first and last name for the record?
My name is Jeff Carroll, JEFF CARROLL.
And what do you do for a living?
I'm a sheriff's deputy for the Burnett County Sheriff's Department
How long have you been a sheriff's deputy for the Burnett County Sheriff's Department?
since December of 2023.
Do you know a person named Bailey Mangan?
I do.
Who is that?
He's also a sheriff's deputy for the Burnett County Sheriff's Department.
Have you worked with him?
I have,
Do you know his work to be trustworthy and reliable?
yes,
Have you reviewed his work as it related to an incident on September 10th, 2024?
yes,
Specifically related to a controlled buy into someone allegedly named Travis Wessles.
yes.
What did Deputy Mangan do that day in regards to that controlled buy?
Deputy Mangan had met with an informant who advised he was arranged to purchase methamphetamine from Mr. Wessels at a predetermined location at around 6 p.m.
And did he meet with the CI there?
He did meet with a CI.
What did he do next?
He had searched the CI and their passenger of the vehicle. They searched the vehicle and did not locate any contraband items.
And what did he do after that?
After that, they provided the CI with 2 recording devices and followed the CI to the predetermined location, the laundromat and siren.
Did he observe anything of police interest at the laundromat and siren?
Yes.
What did he see?
Deputy Mangan observed Mr. Wessels arrive in a black Ford Ranger. He observed Mr. Wessels meet with the CI, going into a vehicle together, and then leaving.
What happened next?
After that, the CI left from the laundromat to another predetermined location, which was observed by Deputy Mangan, met with the CI, and had searched them in the vehicle. Did not locate any contraband items until the CI had informed him. They had exchanged $240 for a flashlight, which contained approximately 1.97 grams of methamphetamine.
Can I ask, is that a literal flashlight or is that a new term for narcotics?
The report indicated it was a flashlight. I believe it was a literal flashlight.
Okay, thank you.
How did Deputy Mangan know it was methamphetamine?
He had field tested the substance and it field tested positive for the presence of methamphetamine.
What did the CI add anything else onto that explanation?
The CI advised he had given Mr. Wessels $240 and in return he was given a flashlight containing methamphetamine.
Okay. The laundromat and siren, is that in Burnett County?
Yes,
Did Deputy Mangan see the individual identified as Travis Wessels?
yes,
And prior to today, did he identify an image as depicting Travis Wessels to you?
yes, he did.
Do you see the person from that image in court here today?
Yes, I do.
Could you state where they are and what they're wearing?
Mr. Wessels is sitting next to defense counsel wearing a red t-shirt and glasses.
Let the record reflect that Deputy Carroll has identified Mr. Wessels.
I have no other questions.
All right, Mr. Belisky.
Thank you, Your Honor. Deputy Carroll, good morning.
Good morning.
Deputy, you were not a direct part of this operation, correct?
No, I was not the investigating deputy, nor was I an assisting deputy in this case.
So you were not personally present during this incident,
That is correct.
and you did not personally observe any of the events which occurred as part of this incident.
That is also correct.
And you did not personally observe or speak to any of the parties during this incident, correct?
That is also correct.
Thank you. Deputy Carroll, your testimony here relies in part on the report drafted by Deputy Bailey Mangan, correct?
Yes,
And Deputy Mangan made a positive identification of Mr. Wessels at the scene, correct?
yes,
And that identification was made based on prior police contacts?
I can't recall what the criminal complaint states.
Thank you. I have no further questions.
Can you redirect?
No.
You may step down. Thank you. Any further witnesses?
No witnesses, though I'd ask the court to take judicial notice of the bond in Polk County 24 CF 204. this is an old case and that's an old bond, but the bond shows that the case was still open when this offense occurred on the date testified to.
Pulling up the case now. Court pulled up Polk County case number 24 CF 204, State of Wisconsin versus Travis Jeffrey Leonard Wessels. Court will look at the bond. The bond reflects not to possess or consume controlled substances without a prescription and only in the amount and frequency as prescribed, not to possess or use drugs without a prescription or drug paraphernalia, subject to testing to determine compliance upon reasonable suspicion or at the court's directive, no use or possession of any synthetic urine or masking agents. The court will also note that bond went into effect May 20th, 2024. This matter resolved on February 24th, 2025. This incident was the result of something in September 10th, 2024. Therefore, the bond was in effect. I will take judicial notice. Mr. Feliski, do you have any witnesses?
No, Your Honor.
Mr. Feliski, based on the testimony that you've heard and those things, do you wish to make an argument or just stand mute here today?
Your Honor, I object to the bind over. Otherwise, I
Well,
stand mute.
I have to ask this, unless you're going to argue more, but you.
No, Your Honor.
Other than you object.
I object, but I stand mute otherwise.
Okay, no, that's fine. Okay, I appreciate the objection, and it is noted. Mr. Wessels, I don't know your criminal history. I don't know anything about you. I quite honestly think this is the first case you've been in front of me, but I can't guarantee that. But you just don't look familiar. Nothing's clicking with any facts. So I don't know anything about you. And so that means I don't know your criminal history, and I don't know if you've been through a preliminary hearing before. If you haven't, I will tell you some things about it. If you have, I'm just giving you information you should have been provided before. At a preliminary hearing, the bond is on this, or the burden is on the state to prove a felony was probably committed and probably committed by you in Burnett County. And the court must view all evidence in what's called the light most favorable to the state. So if there's any question, it goes to the state's credit. Okay. So it's kind of like a little scale like this. And the court can't judge whether or not, based upon the facts that have been elicited today or that are in the criminal complaint, whether or not these are the correct charges or whether or not there's any defenses or anything of that nature. For this hearing, it simply is to find, did a felony, any felony, probably occur and was probably committed by you in Burnett. All right. So it's a very low burden. So based upon the testimony and hearsay is admissible, that means that anybody can testify off of the criminal complaint. It doesn't have to be that specific officer that was present at the scene. Again, I'm just giving you that information. Your attorney has probably already talked to you about these things. But based upon that, the court will find that there is probable cause to bind over. So it will define a felony was probably committed and probably committed by Mr. Wessels. So I do find the probable cause information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Would you like to proceed with an arraignment or set it for another date, Mr. Feliski?
Your Honor, we'll proceed with the arraignment today. As the information mirrors the complaint, I trust that Mr. Wessels understands the charges here and the maximum penalties. We'll waive any additional reading and to all counts enter in pleas of not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial and you would be entitled to a speedy trial should you request one. What I'm going to do right now is get a date for a status conference. Oh, but I opened the wrong thing. I have you coming back September 10th at 9:30. Does that work, Mr. Polisky? September 10th at 9:30?
That will work, Your Honor.
And that wraps this courtroom segment. We saw everything from a waived preliminary hearing and a negotiated resolution to a full probable cause hearing involving an alleged methamphetamine transaction. The key takeaway is that a preliminary hearing is not a mini-trial. The state only has to show probable cause, and the evidence is viewed in the light most favorable to the prosecution. With the case now bound over, the real fight moves to the next stage. What do you think? Was the court right to find probable cause based largely on the testimony and police reports presented here?